your preferences.
Do the other committee members have
I have it.
access for it? And welcome back, folks who are watching. This is the Senate Committee on Government Operations meeting of Wednesday, May 7th. And we're going to take up further testimony on H1, which is the bill to enact relating to accepting and referring complaints by the State Ethics Commission. And we're going to focus in on what was drafted on April 21st,
She's some pro.
2025. Welcome back, Senator. This is draft 1.1 of H1. And in case people haven't read it lately, I wanted to have our attorney go through it very quickly with about a $40,000 view of it. Just so, and I guess we have to say goodbye to Senator Wakefield.
Yes, I just want to say I support the most recent draft that I saw that was sent to us.
Okay, this is the one previous to that, 1.1.
Okay.
Never mind. Yeah, we can talk about it, but generally, you know where I stand.
Yes, okay.
Well, this is Michael Grady with Legislative Council. As you've discussed several times in the past, there is an existing procedure at the State Ethics Commission for accepting and referring complaints to multiple different bodies. Part of the concern is that that consultation or that referral process requires the judicial branch and the legislative branch to engage with in a consultation with the State Ethics Commission after they receive the referred complaint, which has raised constitutional issues by both the legislative and judicial branches. So what you have in draft 1.1 is an amendment to address those constitutional issues while still providing for input from the State Ethics Commission when a complaint is referred. On page 1, line 19, striking section 1223A, that's just a cleanup. There is no 1223A. And so that is not necessary. The striking of including the commission itself, we're going to come back to that because of some future effective dates. You will see that item will be reinserted in subsequent sections. Under subsection C, you'll see that the title of the subsection is being changed from consultation on unethical conduct to commission advice on the application of the State Code of Ethics on referred complaints. You will see that if the executive director refers a complaint, the executive director shall signify any likely unethical conduct described in the complaint, and except for complaints related to municipal code of ethics, they shall specify any application of the state code of ethics to the allegations presented in the complaint and include a recommended action. So let's clarify what that means. When a complaint is referred, that the complaint referral will include application of the state code of ethics to the allegations and a recommended action. The required consultation on page 3, lines 3 through 6 would be struck, and it would be struck for the legislative branch, the judicial branch, and those entities of the executive branch that are currently listed in that consultation. So those Department of Human Resources, campaign finance, etc. And there's also a clarifying provision on page 3, lines 7 and 8. Any advice the commission provides to the referred entity under the subsection shall be confidential and non-binding on the entity. And you will see that there's also a conforming change regarding confidentiality on lines 11 and 12. That is because later on you will see that there was opportunity for the consultation records between an entity and the state commission to have been non-public, to be public, I should say. And this is clarifying that because there's no more consultation, there's no more need to refer to that exception in 1231. Then on section 2, remember how I said you're going to see that including the commission itself coming back in because this is a future effective date. And then you'll see the acceptance provided for in section 1231 again here. Then the 1231, this is the records of confidentiality, the reference to the consultation records as being public, that is being struck. There were some concerns, and I think it was either Secretary Bloomer or Clerk Rask that raised them about consultations being used against a branch or against a complainant or against a respondent, and that didn't seem equitable. And then you get to the effective dates. This is pushing out the effective date of the commission's enforcement authority because of concerns of inability to enforce because of lack of staff and lack of funding. It's being pushed back from July of 2025 in some places to 2027. And then on page 5, lines 13 and 14, the expansion of the commission's powers, which takes effect this year, September 1, 2025, would be extended to take effect on September 1, 2027. And so that's effectively the major changes. Again, the commission investigations, commission hearings, their enforcement authority moved from September 1, 2025 to 2027. And then the effective dates for this act, it takes effect on September 1, 2025 and supersedes those provisions of 2024, number 171 that conflict with the language in this act. And then the future provisions relating to the commission itself and the confidentiality under 1231 take effect September 1, 2027. And then the enforcement provisions take effect September 1, 2027. Let's see. So summary. Instead of a required consultation when a complaint is referred from the State Ethics Commission, State Ethics Commission shall, at the time of the referral, provide an application of the State Ethics Code to the allegations and a recommended action, and the State Ethics Commission's enforcement authority, inspection, hearings, etc., would be postponed 2 years until such time, hopefully, as they have staff and or funding.
Thank you, Michael. Committee members have any questions? Again, I'm sorry that Senator Clarkson isn't with us today. She had to take the afternoon off, and Senator White is now in a committee of conference in the transportation bill, I believe. So that's where they are. And if there aren't any questions, you're certainly free to go.
No, great.
Thanks, Michael.
You too.
Christina Sibert is with us. She's Executive Director of the Vermont State Ethics Commission. Welcome.
Thank you. So, thank you for allowing me to testify on the new draft H1. So just to summarize, the Ethics Commission continues to vigorously oppose H1 is against the public interest. The present draft of H1, dated April 21st, does several things. First and most significantly, postpones the effective date of the Commission's investigatory and hearing authority until September 2027.
Slow down a little bit.
It postpones the effective date of the Commission's investigatory and hearing authority until September 2027. And I did hear Mr. Grady reference this as being enforcement powers, but it's not conceived to be enforcement powers. It really is just investigatory and hearing powers. And that did come up on the previous conversations because right now the makeup of the commission does not include an appointee with the governor. And so when it comes to enforcement, we didn't feel comfortable that enforcement was something that we would be able to do at this juncture without some changes to the makeup of the commission. So second, the commission is barred from investigating complaints. Each one requires the commission to flag likely unethical behavior based solely on the allegations made in the complaint, and then make recommendations as to what actions the referring agency should take regarding the complaints. Third, this is a rollback from what the legislature agreed to last year. which at the time was seen as a sensible and sound path. So that agencies that receive complaints referred by the Ethics Commission under H1 would no longer need to consult with the Ethics Commission, depriving them of the benefit of a conversation and how the code of ethics should be applied, really undermining the intent and purpose of a uniform code of ethics. So really feel like H1 is a retreat from Vermont's commitment to governmental ethics. H1 in its present form represents a retreat from what's decided on previously. In 2027, after consistently being ranked one of the lowest states in terms of governmental ethics, Vermont enacted Act 79. The act made a commitment to Vermonters that its government took ethics seriously. It established the state code of the State Ethics Commission. The commission had limited authority, but its establishment represented a first step on the path to a vibrant independent agency, which is in line with, majority of other states. Last session, this committee was instrumental in setting up a plan to give the commission investigations and hearing authority beginning in September of this year, just a few months from now. The bill also gave the commission authority to make procedural rules for investigations and hearings. For Vermonters, this was long overdue. Citizens would now be able to file complaints with an independent office, and this is a complaint that we hear a lot in our office. People are really looking for independent investigatory enforcement authority when it comes to complaints, particularly when they're filing complaints related to an office that is going to be doing the investigations. Additionally, it resolved a long-standing problem: what to do with complaints where there is no referral authority. And I think this is just a reminder that the reason the investigatory hearing powers for the commission came about, it's our understanding, because we didn't actually ask for this last year, this is something that the legislature wanted. And the reason this came up is because we had a number of complaints where there was no place to refer the complaints. So that relates to statewide elected officials and certain categories of, other officials such as state's attorneys, but also board and commission members. So we've had complaints filed with our office related to board and commission members, related to state's attorneys, that didn't implicate the rules of professional responsibility, and we've had to close them out. So we've reached out in several instances to commissions to say, we have a complaint against your commissioner. Would you be able to handle this complaint? There's nowhere else to go. They didn't feel comfortable doing so. So this is one of the reasons why the Ethics Commission was given these powers last year, so we could handle those categories of complaints where there's no place to refer them, so that we handle the very minor issues that could be resolved through a resolution agreement. And then in the middle, those complaints that didn't really fall into either of those categories could continue to be referred to outside investigatory bodies. And then there would be a benefit of a conversation just to make sure everyone had the same understanding of the state code of ethics. So that is how this came about last year. And that's why the consultation requirement was agreed on, or that's my recollection of one of the reasons for the consultation requirement. So the H1, all of that would be gone. And there's really kind of a rollback to a place where, we feel like state government right now is saying that next steps can wait and for another 2 years, which is a significant amount of time in the future. And we would hope that if we're going to put things off and put the conversation off until a later date, we could at least do it next year. I'm not sure why this decision was made for 2 years, but I do feel like what we hear in our office from people who reach out to our office is they do feel like what's happening now and the path that we're on is a long time coming, and they'd like to see more of it, not less of it. So the committee, the legislature suggested that the commission lacks the resources to begin enforcement duties, and that is true, but that is also something that the legislature could solve in terms of a problem. The legislature continues to staff the commission as it was in 2027 with a part-time director. In 2021, we did have the addition of a part-time executive assistant, but that was before all of our new responsibilities were given to us. So we don't have attorneys, we don't have investigators, and we don't have educators. And so right now, this continued, request for more staff and the denial of more staff, it starts to feel like there's a portion of government that feels more comfortable with having the laws on paper, but not when it comes to actually putting the accountability framework in place. And we do believe that the public would definitely disagree with this approach, particularly at this moment in our nation's history when so many Vermonters, including many legislators, are protesting the rollback of government accountability at the national level. And now we're seeing the same thing happen in our state. So moving on to the flaws that we see in H1 right now is that H1 tells the commission that it cannot investigate complaints. However, it tells the commission that it must make recommendations on what an agency should do with the complaints that are referred, even when the complaint may contain little information, and it is known whether the information in the complaint is factually accurate. And I can attest to the fact that we get numerous complaints in our office. Some of them are, fully baked in the sense that people have really done their homework. They understand how to file a complaint. There's a lot of facts. There's a lot of additional information, and some are just 1 or 2 pages with a couple of sentences here and there. So it'd be required to treat both of those complaints the same in the sense that we're being requested to essentially judge whether there's any likely unethical conduct, but actually go further than that and recommend an action. And it's really unclear what the intent of that portion of the new requirement that's referenced in H1 is. Are we supposed to recommend that somebody, find the respondent in the complaint, I don't want to use the word guilty, but we find that they have violated state code of ethics? We can't possibly do that on the face of a complaint that contains allegations and very little facts. But at the same time, we don't have the power or the resources to do further investigation. And so for that is where, we really see a problem with this new proposal, is we're being asked to flag likely conduct on the face of a complaint where there's very little information usually, and then also say what somebody should be doing with the complaint. So that actually puts us in a position where, you've heard the constitutional arguments over the last few weeks about separation of powers and whether, the Ethics Commission could conceivably be judging the qualifications of members through a conversation, through engagement, that we could be doing that. However, this actually requires us to make a judgment. And so that includes complaints that come in related to attorneys, judges, legislators. It requires us to say whether we think there's been a violation on the face of the complaint, and then say what the referral entity should do with that. The consultation requirement didn't require either of those things. It just required a conversation with the referring entity about the facts as they understood them, and where we thought maybe, they should ask additional questions, what we saw on the face of the complaint. If we thought, if that was borne out to be true, would that be a violation? Yes or no? And that was always conceived to be confidential information that would go no further than a referral entity, and it would not be discoverable in our office by anyone seeking, to get documents in the Public Records Act. So that, I think, is one of the parts that is the most confusing to us in this new draft, is that I think it was conceived to be something that was more limiting than the consultation requirement, but I think it actually goes further and requires us to weigh in where people are not really interested, in having us weigh in. And finally, I think the other issue that we brought up before when it comes to H1 is that it will lead to an inconsistent application of the Code of Ethics. So the bill that was passed by this committee last session required that agencies consult with the commission, which makes a recommendation. Through this, agencies can make informed decisions based on an accurate, consistent interpretation of the Code of Ethics. There would be consistent interpretation of the code coming from a single knowledgeable source, the Ethics Commission. And that's because we work with the Commission every day. We work with the Code of Ethics every day. We are the people who understand it the best. So every referral entity, they have their investigators, they have their attorneys, they're used to working on personnel issues, but the Code of Ethics is a different animal, and that's something that we exclusively have expertise in. And that is the role of Ethics Commissions in all of the states. So essentially, the Ethics Commission serves as the body who has the interpretive authority when it comes to the State Code of Ethics. So this is the consultation requirement was designed to give referral entities the benefit of our expertise. Even if they're not going to follow our expertise, they're getting the benefit of it. And it not only benefits them because, potentially it's a struggle to understand whether, certain facts fall under the State Code of Ethics or not. We can help them with that. But the idea that it also helps the respondents in a complaint, right? Because they're going to understand that they're being treated equally across the board, regardless of what branch of government they're in, or regardless of what their position is, that they have somebody on the outside kind of giving an impartial assessment of the facts and how the State Code of Ethics applies to those facts. And if we get rid of that consultation requirement, what really happens is they're going to have inconsistency in the law. And I don't think that that is the goal. And you're going to have inconsistency in interpretation of the law. And what we're really seeking here is just to make sure that if you are a security guard in the judicial branch, if you're a judge in the judicial branch, if you're a legislator, if you're an administrative assistant, when it comes to State Code of Ethics, everyone is being treated the same. And the one way that we can help do that is to make sure that everyone has the same understanding of the State Code of Ethics and what behavior is a violation and what behavior is not. So in summary, I just say that we don't think that H1 serves the public interest here. We do understand that the State Code of Ethics, the ethics framework in Vermont, is relatively new and people are still getting used to it. I don't think the Ethics Commission has done anything thus far to really cause people to question our judgment when it comes to giving advice about ethics. I understand people in this room are not familiar with the advice that we give. They haven't seen it. They may or may not have read the advisory opinions, but the bulk of our work is not, advocacy of the legislature. That's part of what we do. But what I do every day is I'm on the phone answering emails, giving people advice when they call in to ask us for assistance. And, as of yet, I have not heard any complaints in terms of the quality of the advice we're giving, that we're not acting impartially, that we're not, as helpful as we can be. And that is really what I think we should be judged on in terms of our effectiveness and, moving forward with the framework for ethics in Vermont. And part of what we're really trying to do here is just make sure that the public has confidence in their government, right? That there's transparency, that everyone is acting ethically, and that's something where Vermont has been lagging historically. I mean, we all know that. And right now we're trying to move forward. It just feels like this year was a very big jump back. This was, this is my 4th year with the legislature. The first 3 years were a very different experience for me than this year. And I'm still not sure, why exactly, but I'm really hoping that, when we're considering the public interest, we're really thinking about what is going to cause Vermonters to continue to feel confident that the Ethics Commission, that state government, that the legislature is really working in their best interests. That's all I have.
Okay. I thank you very much, and I sincerely mean this when I say it. I know this is a difficult time. If this bill does go out of this committee with a favorable vote and then gets to the Senate floor, it may increase that sort of negative feeling. And I feel badly about that. I really do. And I know that there were some constitutional disagreements between our legislative council and certainly Peter Teachout and Paul Gillis. I understand that. I guess that's not unnormal in a legal way. If you have 5 attorneys weighing in, you may get 5 different opinions. You may get 6 actually. So I understand that. I'm trying to be sensitive to your feelings and the other issue. So aside from the constitutional issue, and that would involve the panels of both the Senate and the House, and also Judicial Conduct Board and Professional Responsibility Board in terms of the judicial piece. But the other part of that is the funding. And, we recommended, this committee did send a recommendation across the room to get you the funding that you had requested. They filtered it through all the other asks that people have made. This year, we had at some point, I think, $100 or $150 million more in requests than they had money. And so it didn't happen. But I don't want you to think that this committee doesn't appreciate what you do. Senator Clarkson and I were on the original Government Operations Committee when we created the Ethics Commission. So I have a soft spot for it. It's unfortunate the way things wound up this year. And
yeah, and I would say it's unfortunate because, we have had to stop offering municipal services, and that is the bulk of the work that we've been doing recently. Yeah. And we have so many municipalities who are really trying to do the right thing, really trying to comply with the municipal code of ethics, who regularly call and ask us for advice. We have over 200 municipalities who've appointed their ethics liaisons to communicate with the Ethics Commission. And I've had to stop offering those services because it's just overwhelming. And so, for our office, it's just, it hurts our office in the sense that, we really want to be able to be offering those services, but it really does hurt the municipalities and, the members, the citizens of those municipalities who are really trying to do the right thing and are really looking for guidance on these issues.
okay. Committee members, do you have any questions for Christy?
This may be a question for Christina. It may actually be diving really deep into something well beyond that. And so other states have structures like this that don't run afoul of those state constitutions. And so I guess my question, and this is why I say it may not be for Christina, is how do those states navigate that? Are their constitutions wildly different than ours?
No, they're not. And actually, TJ Jones, who you've seen on the video, is here today, and he can answer that. He actually wrote a memo on the Houston in his testimony previously. So what other states do is they set up their ethics commission, much as we've set up ours, and that they're independent agencies that are set up in a branch of government for administrative purposes only. And that is how our ethics commission is set up. And we did make this recommendation on the House side. I'm not sure we discussed it on this side, where we said we are already set up within the executive branch for administrative purposes only. No executive power flows through us. The governor's office does not, oversee us in any way. And so that is how other states have set up their ethics commissions. That's how we are set up. So we suggested adding language in statute, just making it clear that we're set up in the executive branch for administrative purposes only as a way to resolve the continuing constitutional concerns. Because yes, other states have ethics commissions. This is how they set them up. If we're looking at neighboring states, plenty of neighboring states have ethics commissions that do hear complaints against legislators, against attorneys, against those categories of people. And maybe I should stop talking because I do know that TJ is the expert. If you have
Sure. Yeah. No, so I guess I know I was also part of the original conversation just on the House side setting this up, and I guess do those other states, and this may be where I'm actually asking TJ, is do those other states also have provisions in their constitution that only legislative bodies may set the qualifications and reprimand? Because that's my understanding of sort of the piece that we've heard from some is a problem here.
I mean, I think the issue is that where other states have come down on this is that core legislative functions are exempt from, state code of ethics in terms of conflicts of interest when they relate to your core legislative functions. There's exempt from state code of ethics. Those complaints can't be handled by the ethics commission, which is actually also what we've done here. So I think that's the dividing line, but I would like, if you want to hear from TJ, I think that's probably better.
Almost all the states on the Eastern.
Chris, you just identify yourself for
I
that.
apologize. My name is Thomas Jones. I'm a professor of government accountability, and I also consult on municipal and state ethics.
Thank you.
On the Eastern Seaboard, most of the states have that identical provision, and some of them, like Vermont, it predates the federal constitution, which also has a similar provision. The way they work through that has been not a smooth ride all the time, but the result is always that there is a relationship and a means of communication. And the states deal with that differently. In Connecticut, for example, all of the state agencies and the legislature appoint a legislative liaison or an agency liaison who's solely devoted to ethics. And there's nothing in the statute that mandates their college, but over time, a trust develops.
Mm-hmm.
And in most of the states, particularly New England, there's a high level of trust between the ethics agency and the legislature. And for many of them, I don't know how they developed that. I know how they did it in Connecticut. I'm very familiar with that. And it took time and a couple of legislative tweaks mandating the appointment of legislative liaisons. But the trust element was key to all of that. That there was, in contrast, this has been a wonderful process being involved. I sat in this room for the first time in 2018, and so I've sort of watched this grow over time. But there's still, at least to my outside eyes, there hasn't been that relationship of trust that's been built up. And it probably delves from the fact that the agency doesn't have enough resources, even if everybody appointed a liaison, that there's not enough staff there to deal with it. I'm confident that over time, that Vermont will end up more like Connecticut, Rhode Island, Massachusetts, and less like Wisconsin and New York, where there continues to be a high level of distrust. Because what happens there, and what has happened there, is that the agency is deconstructed and reconstructed every 4 to 5 years. And so it's always a fresh start and always that process of building trust. But they never sort of reach that level.
Do any of those New England states or Eastern Seaboard states with sort of similar provisions in their constitution or identical ones to Vermont have the construct that we put in place last year? Because it's not being put in stage one. We're getting rid of it.
I will tell you when this came up last year. I thought it was a brilliant idea. It wasn't the commission's idea. This came up in the process of discussions. I think on the House side, I can't remember, but it came up in the process of discussions. I thought it was a great idea. I didn't know it was going to be a constitutional foo-for-all. I thought it was a good idea. I'm not aware that anybody has that exact language that says you have to talk to the commission. Nevertheless, it creates a bridge that allows that trust to develop. And so I was behind it 100%.
Yeah, no, and I certainly support the concept. I mean, I support it, provided it really isn't unconstitutional. And what I'm sort of looking for is, are there similar provisions with similar constitutional things that have held up?
Yeah.
You know, and of course, I think in any instance where we've got folks on one side saying that's not constitutional and folks on the other side saying that is constitutional, it's up to the courts to decide. I don't know that I want to.
No, and in fact, I've been, if I can speak candidly, I've been somewhat surprised watching as an outsider here. Because normally what would happen is those people that had disagreements about the constitutionality and bona fide agreements, disagreements, you know, separation of powers is always an issue for commission. What usually happens is the door closes and a conversation is had. And the subject of the conversation is, okay, we both disagree, but we both think this is a good idea, at least where it's headed. How can we get there? And they work through it. And that has been one of the things that's baffled me, that hasn't happened here. Because I do think there are ways to make everybody satisfied that the constitutionality is protected, and that relationship of trust can start to build.
Yeah, no, and I really want to build that. It's a strong ethics commission and transparency is really, really important to me. And I also recognize, and I'm not certain, but you know, when I think about appointing legislative liaisons, I assume those are legislators, and I also assume Connecticut's legislators, maybe they have staff, maybe they are paid more than, you know, $13,000 a year. Maybe they don't also have to have other jobs. And so I also sort of think of like some of the just struggles of part-time citizen legislature in building that type of relationship.
One of the reasons I limited it to the Eastern Seaboard, first is because most of their constitutions predate the federal one. But second of all, they have you know, legislative staff that does this. They're all citizen legislatures, almost all.
Right, but we don't have staff.
Right. and that I recognize that makes it more difficult. And this one's difficult, you know, resource wise in Connecticut. Massachusetts somehow managed to get funding, so it was never a problem. Rhode Island, never had, I mean, Rhode Island, they got to a point where they had to vote it into the Constitution. So Rhode Island's conditions seem a little bit different. But they got to a place where there were people, because it's in the interest of both sides to have people that are able to talk. In the long run, it saves time for everyone.
Yeah.
That you can pick up the phone and say, well, what do you see about this? We're about to send whatever, you know, an investigator. We're about to do this research. To have the conversation of, I don't know that that's, maybe you want to look at this. It's still up to you what to do, but you know.
No, that's really helpful.
And the federal government have experienced like ethics liaison in the context of having member of human resources or an attorney working in the office serving in that role.
And to be fair, nothing in H1 would prohibit either legislative panel or the judicial wards, conduct warden, responsibility warden, from reaching out and asking for consultation. It's just a requirement that seems to be the stumbling block for those who favor one interpretation of the Constitution. And again, I'm not trying to take sides of this necessarily. I just want to make that point that if the Senate ethics panel wanted to reach out to you, they could, after you file the initial complaint or referred it, they could say, hey, come on in, let's have a chat. And the trust that Tom's talking about may begin to be developed as that process gets initiated. So there's still that possibility, I think.
No, I understand. I'm gonna be honest, when the consultation requirement came up last year, like I said, we weren't as involved in this section of the legislation, right? We do think it's a really good idea. But part of the reason was, we didn't have that level of engagement with certain, entities.
Mhm.
DHR is really the one that's reached out to us and wanted to have a conversation
Yeah.
about this. And so this was a way to like make sure it was institutionalized and so that it was consistent.
Okay. Well, thank you all for coming in, Ben. Pleasure to see you. Paul, thank you so much. That's all we have for today. We have more work to do, I'm sure, tomorrow with another bill that seems to be growing. Every day there's another provision or two being added to 397, which is emergency management flood recovery bill. So